Legacy. Law also promotes your opportunity to leave a lasting legacy for years or even generations beyond your demise. The above chapters have briefly touched on some of those legacy opportunities. They begin with your opportunity to accumulate earnings, amass and invest savings, acquire and hold appreciating assets, and build or create things of value. Law recognizes your property and holdings as assets of your estate after your passing. You have the law's support and encouragement to provide, through a will or trust, for the distribution of your estate after your demise, for the benefit of those family members, future generations, charities, causes, or other individuals and organizations you wish to favor. You may also form and fund a foundation, or form, support, and operate a charity as your legacy. This chapter addresses those opportunities in brief. See the guide Help with Your Legacy for greater detail on opportunities to create and leave a legacy. Will. Law encourages individuals to provide for the orderly disposition of their property and payment of their debts after demise. State laws authorize individuals to execute a will by which they provide for the administration of their estate after death. A will provides for payment of expenses of administration and debts the decedent owes, and for distribution of remaining assets. When you execute a will, you decide on your heirs. If you do not execute a will, your estate passes by the laws of intestacy, generally to your spouse and adult children, depending on varying state laws. To execute a valid will, you need to reduce your wishes to a writing that you sign at the end, with 2 adult competent witnesses also signing. Notarization of signatures may confirm their validity without further attestation. State law may also hold valid a will in the testator's handwriting, signed at the end, even without witnesses, provided that witnesses can confirm the testator's handwriting at a probate hearing. Retain qualified legal representation to help you execute a valid will expressing your wishes. Heirs. Law permits you to choose your heirs under a will. Your heirs may certainly include your spouse, children, grandchildren, and other natural objects of your affection. A testator may leave everything to a surviving spouse, simply to assure the spouse's support, leaving the spouse to convey assets to children and grandchildren by gift or by will on the spouse's own demise. If a testator leaves nothing to a spouse, state law may authorize the spouse to elect a statutory share of the estate anyway, again for support purposes. Testators generally treat children equally or equitably, although, again, the testator decides. If one or more children are minors or financially irresponsible, the testator may convey their portions in trust for management by a responsible individual. Testators may also bequeath assets to friends, charities and their causes, religious institutions, and other individuals and organizations. Testators also may bequeath either specific items of real or personal property, or a percentage share of the estate, or a combination of such bequests. You may modify your will as often as you wish with an amendment, also called a codicil, following the same procedure for executing a valid will. Retain qualified counsel for advice and assistance in making your wishes known in a properly executed will. Representative. Law permits you to choose the personal representative, also called an executor or administrator, of your estate. The personal representative carries out your wishes as expressed in your will, while following the probate laws and procedures. Testators commonly designate a spouse, trusted sibling, or stable and wise adult child as their personal representative. The will names the personal representative. Wills often name a successor personal representative if the first choice cannot or will not serve. Wills may also name co-personal representatives if the testator prefers to have 2 or more representatives sharing control. The personal representative typically retains a probate attorney to advise and assist with probate administration, especially for more valuable and complex estates. You may also choose a corporate personal representative whose professionals would carry out the estate's administration. You may also recommend a guardian or co-guardians, typically a married sibling or married close friends, for your minor child or children in your will, which may be your most important act of all. Trust. Law also permits you to place assets in trust for the benefit of minor, dependent, or mentally incompetent family members, both while you are living and after your demise. A trust is common, for instance, for the financial support after the grantor's demise of a mentally incompetent child, or of an elderly, infirm, or unsophisticated spouse who might fall under the influence of others against the spouse's own interests. You may alternatively establish a family trust to provide support for your future family generations if your assets are sufficiently substantial. A grantor often funds a family trust established during life from a pour-over will at demise. The trust names the beneficiary or beneficiaries and the person or corporate entity to act as trustee. A trustee has the fiduciary duty to carry out the terms of the trust for the beneficiary's best interest. Trustees owe a duty not only to carry out the trust document's terms, but also duties of loyalty, reasonable care or prudence, impartiality, monitoring, reporting, and not to commingle trust assets. Grantors execute trust documents under requirements similar to those for a will. Retain a qualified legal representative to advise and assist you in preparing and executing a trust, if in your legacy interest. Charity. Law also encourages you to establish, operate, and support a charitable organization to further your legacy. Internal Revenue Code Section 501(c)(3) exempts from federal income tax qualifying organizations operated exclusively for charitable, religious, educational, scientific, literary, or public testing purposes. Forming your own charity with a nonprofit corporation form, charitable identity, volunteer board, staff members, and charitable mission can greatly aid your community. Charities qualify for tax exemption under a public support test, meaning that members of the public provide a substantial portion of the charity's operating expenses. You may also make tax-deductible donations to your own or another 501(c)(3) charity, providing you itemized deductions and otherwise qualify under the tax code. See the guide Help with Your 501(c)(3) for further information on how to start and operate a charity. Foundation. Law also encourages you to establish a foundation to fund charitable causes. Individuals or families with substantial assets may find that making charitable donations each year does not sufficiently carry out their desire to support charitable causes long term. A foundation is a tax-advantaged grant-making organization funded by a single individual, family, or corporation, typically with funding or a funding commitment of at least $1 million. Foundations often bear the name of the individual, family, or corporation funding them. A foundation does not carry out charitable activities, nor does a foundation solicit public support. The foundation instead gives grants to other 501(c)(3) charitable organizations to carry out the charitable mission the grant describes. You may establish a personal or family foundation to operate for a defined period or in perpetuity for your children, grandchildren, and future generations to operate, giving grants to charities that meet your foundation's mission. Retain qualified legal representation to assist you in establishing a foundation. Fund. Law also encourages individuals and families without the substantial means for a foundation to participate in a community foundation by establishing a community foundation fund. Community foundations have a special legal status that permits them to operate with the advantages of a private foundation, but to establish separate accounts for individuals, families, or corporations to fund. A community foundation enables you to establish a fund in a smaller amount than that which a private foundation generally requires, and to avoid the expense and administration of a private foundation. Individuals and families fund community foundation accounts with donations of $5,000, $10,000, $50,000, $100,000, $1 million, or other amounts. You may designate the charitable cause or interest your account would fund, with grants evaluated and issued by the Community Foundations Board. Consider a community foundation fund as an alternative to charitable donations or a personal, family, or corporate foundation to further your legacy. Thanks for watching. Get more tips plus stories, illustrations, forms, and reflections in the guide at the link in the description.